seconds to go. Start. Having considered that no complicated legal question has been involved in the matter and the presenting officer appointed by the disciplinary authority is neither law officer nor a legal practitioner, and keeping in mind the regulation 44 of regulation 2010 on engagement of legal practitioner during the inquiry, the request to permit him to represent through legal practitioner came to be declined by the disciplinary authority, which was communicated to him via communication dated 27th May 2020. Again, a request was made by the original writ petitioner to permit him to engage a legal practitioner as his DR in the inquiry proceedings, which again came to be rejected. During the inquiry proceedings on 11th August 2020, the original writ petitioner submitted a consent letter of one Shri Mahesh Kumar to be engaged as his DR. The said request was turned down. Again, a request was made to permit him to engage any legal practitioner or any retired officer from the bank as his DR, which again came to be turned down by the disciplinary authority. Aggrieved by the order passed by the disciplinary authority dated 19th August 2020, the original writ petitioner approached the High Court by way of SB Civil Writ Petition number 8363 of 2020, inter alia praying that he may be permitted to engage any legal practitioner or retired officer of the bank as his DR. The said writ petition was opposed by the bank. Regulation 44 of Regulation 2010 and the circular dated 31st January 2014, as also the guidelines issued by the bank in respect of disciplinary proceeding, that no outsider not associated with the bank can be permitted to act as a DR, were pressed into service. That by judgment and order dated 28th January 2021, the learned single judge allowed the said writ petition and directed the bank to permit the original writ petitioner to be represented through retired officer of the bank in the disciplinary proceedings. Feeling aggrieved and dissatisfied with the judgment and order passed by the learned single judge, the bank preferred appeal before the division bench of the High Court. By impugned judgment and order, the division bench of the High Court has dismissed the said appeal mainly on the ground that since circular dated 31st January 2014 and the regulation 8.2 did not prohibit the utilization of the services of ex-employee of the bank, therefore judgment and order passed by the learned single judge is not to be interfered with. Feeling aggrieved and dissatisfied with the impugned judgment and order passed by the High Court directing the bank to permit the original petitioner to be represented through retired officer of the bank in the disciplinary proceedings, the bank has preferred present appeal. Shri Rishabh, learned counsel appearing for the appellant, has vehemently submitted that in the facts and circumstances of the case, the High Court has committed a grave error in directing the appellant bank to permit the respondent original writ petitioner to be represented through retired officer of the bank in the disciplinary proceedings. It is submitted that the High Court has not at all adverted to Regulation 8.2 of the Handbook of Vigilance Administration and Disciplinary Action, hereinafter referred to as the Handbook Procedure, which has been duly approved by the Board of the Bank and applicable to all kind of matters. It is vehemently submitted that Regulation 8.2 of the Handbook Procedure specifically provides that the defense representative should be serving official employee from the bank. It is submitted that the provisions of Handbook Procedure are binding on all the employees and applicable to all kind of matters. It is submitted that even there was no challenge to Regulation 8 of the Handbook Procedure by the original writ petitioner. It is further submitted that High Court has not properly appreciated the fact that provisions of Regulation 2010 are to be read with handbook provisions in a harmonious manner. It is further submitted that High Court has erred in construing Regulation 44 as permitting outsiders into a disciplinary inquiry. It is submitted that in fact Regulation 44 restricts legal practitioner to be DR without prior permission. Stop.